Hello everyone. The course name is Banking Regulation and Operations. The unit is Paying and Collecting Banker, and the topic that I'll be covering through this presentation is on the dishonor of check. Dishonor of check. A check is said to be dishonored when the payment is not made to a customer on its presentment to the banker. So when is the dishonor of check is considered as an offense. Section 138 of the Negotiable Instrument Act states that the return of a check by a banker because the money standing to the credit of the account holder is insufficient to honor the check or that it exceeds the amount arranged to be paid from the account by an agreement made with the bank is a criminal offense. So dishonor of a check in simple terms is a process where the banker or the drawee bank decides not to honor the payment against the check issued by its customer for some or the other reason. So if a banker is dishonoring the check of a customer for a rightful reason, then it is considered to be a criminal offense on the part of the customer. There are two instances of a check dishonor made by a bank, which are classified into a rightful dishonor and a wrongful dishonor. So what do you mean by a rightful dishonor? Dishonor of a check by a drawee bank for any of the rightful reason. When I say rightful reason, it can be some reasons which are no of genuine no fact, such as insufficiency of funds, stale check, or those kind of things, or some garnishee order is issued against the account of the customer, or the customer account is frozen due to some legal requirements. All these cases can be considered to be a rightful reason, and if a banker dishonors a check due to such rightful reason, it is considered to be a case of rightful dishonor. In this case, there is no remedy available against the banker, but the holder in due course, that is the payee, okay, has remedy both civil and criminal against the drawer. Whereas a wrongful dishonor of check by the banker due to negligence or carelessness by its employees, the drawer may bring an action against the bank for losses suffered by him. The payee has no action against the banker in this case. So this is simply the case of a check dishonor and how no, the banker can dishonor the check in two different situations. In case of a wrongful dishonor, the banker will be at stake and his rights will be compromised in that. Whereas if it's a rightful dishonor, which a bank does, then the customer will be no charged for a criminal offense. So I just hope this gives a good idea about the various kind of dishonor and the process of dishonor as such. Thank you so much.